In this podcast, we now move on to the substantive theoretical discussions, and we ponder a highly complex but glaringly obvious issue, and that is the nature of law. Now, this podcast will be divided into three, where in the first portion we'll consider why it is important that we ask the question as to the nature of law. The latter two portions of the podcast will consider two of the major schools of thought as to what the nature of law actually is. During our long cultural history, legal thinkers have, for a considerable time, puzzled and argued over the nature of law. They have sought to explain what law is and how it came to be, what it does and how it operates. In asking these questions, they've been concerned not only with the law itself, but in trying to distinguish law and other forms of social regulations such as ethics, custom, religious observances, and public opinion. As with other fundamental questions, there is no answer which satisfies everyone. Answers to this question, however, constitute the field which is variously known as jurisprudence, legal theory, and legal philosophy. Sometimes literature is labelled by a particular theory, particularly natural law and positivism, or by reference to a specific legal thinker. We will be looking at the two main theories for the basis of law in depth, before later considering the philosophical perspectives and some other theories as to why we have law. So, to start with the very fundamental question, what is law? The very question, what is law, is a bit of a headache, to be honest, and throws up a number of difficulties, making it rather complex to address. To ask the question at all takes as read that there is some phenomenon called law in the first place. It implies that law is a universally valid an agreed concept which can be understood in isolation. It's a good point to raise at the outset. At best, it can be said that we use the term law as if it were a universal concept. But in our thinking and in our attempts to understand law, we cannot and must not assume that this is the case. Rather, we have to concede that law encompasses a number of different things and cannot be understood in isolation at all. Thus, the question, what is law, has been given a variety of answers. Instead of unanimity about the nature of law, there are a number of differing schools of thought which are in continual debate. One possible reason for this diversity of opinion is the complexity of law, which can perhaps be shown by analogy. Consider a couple dining in a restaurant and ask the question, what are they doing? Now, a number of answers could be provided to that question. Quite simply, you could say, well, they're dining at a restaurant, and that would be irrefutable. But someone else might say, well, they're on a date, they're courting. Someone else might say, one of them is trying to seduce the other. One of them might say, they can't be bothered to cook dinner for themselves. Someone might say they're there to talk about business. Or someone might say that they're worried about the economy and that they're helping to make a consumer-led recovery. Now, some of these answers rely on facts which aren't given, but it could be envisaged that in particular situations, many of these answers could be correct simultaneously. This analogy isn't to suggest that all theories are true and can ultimately be reconciled. It's merely to illustrate how different explanations can sometimes be reconciled because they're made from different viewpoints. To exemplify the viewpoints and the complexity of law, there are many disciplines. For example, the study of criminal law, from a behavioural sciences perspective is called criminology. The ethical quest for fairness in law is labelled as justice, and so on and so forth. There are at least two reasons for the diversity of theories. As noted already, one is complexity, another is the effect of various socio-political ideologies. An ideology provides an explanation of society, but this explanation may also seek to justify society being the way that it is. One of the effects of this explanation may be to compel acceptance of the status quo. This is done by justifying what is and by glossing over the difficulties. So arguably even the most detached and creative thinker is to some extent a prisoner of their own time, culture and circumstances when they're advancing a theory, and they're bound by ideologies which are ever changing over time and also depend on other factors such as religion or even geography. So if we ask ourselves the question, what is law? We can see it's a very complicated, difficult question to address, and that there are a number of different schools of thought on the issue. Law is complex and multifaceted, and so it's a continuing debate to some extent. But is there an answer? There are numerous theories about law trying to explain or justify it, either in whole or in part. We're going to start in this podcast looking at one such theory, natural law. Natural law contrasts with another major theory of law, positivism, which we'll come on to discuss a little later in the third portion of this podcast. Both of these theories are of special relevance in common law jurisprudence because each has been a dominant legal theory, almost an ideology each in themselves. So significant are they that it's not possible to understand a common law system without some appreciation and understanding of these two schools of thought. This is where we will focus then for the majority of the remainder of this podcast. Natural law and positivism are respectively concerned with the fundamental questions of authority and power. Natural law focuses on authority and positivism on power. Power is the ability to compel another person to do something or to exercise physical control over resources. It is the ability to achieve whatever effect is desired, whether or not that's in the face of opposition. Authority, on the other hand, is a moral claim or a de jure claim, i.e. a claim of right. Authority is a right to be obeyed or the recognition of that right by others. A law which is made by a body with authority that acts within its authority is considered legitimate, for example. Power, by contrast, is a de facto claim, i.e. just exercising the power. In the ringing words of Chairman Mao, political power grows out of the barrel of a gun. Might is right. Or put more simply, might is might, and might is enough. But why are these issues even important? Well, if law is to have authority, then we would expect it to reflect morality in order to be respected and obeyed. The law inevitably becomes involved in adjudicating upon moral issues, but to what extent does it reflect social views, and to what extent should it even try to interpret moral debates and translate them into a legalistic setting? Consider, for example, the issue of abortion, a very divisive topic with significantly polarised views, or alternatively euthanasia and assisted suicide. Obviously, in issues of life and death, there are clear moral and ethical debates which most in society would agree the law should find a position on. However divided we may be as to what this position should be or how it should be arrived at, we'll largely agree that the law needs to take a stance, arguably in the public interest. But not all questions of morality are necessarily considered to be in the public sphere, and this is particularly evident when we consider issues of, for example, sexual morality and consensual behaviour in private. Is this a matter for public morality or legal intervention too? These are the questions which come to the fore in the debate as to what the nature of law is. Now, given the foregoing discussion as to natural law versus positivism, let us in the next portion consider then in detail what we mean by natural law. In the first portion of the podcast, we considered the question, what is law? And noted that it was a complex question to answer, as law is multifaceted. In this portion and the next, we'll consider two of the major schools of thought as to the fundamental answer to that question, what is law? So we begin then by considering what is meant by the term natural law. In many ways, natural law as a concept is fairly self-explanatory, and most people could probably hazard a guess as to what is meant by the term. Natural law at its most basic is the idea that law is a set of immutable principles or universal truths for all, based on what naturally is right and just and fair. There is obviously more to it than that, and that really is what we're going to come on to discuss, but that's it at its most fundamental entry level. The concept of natural law has taken several forms and has a long history. Both Jewish and Greek thinkers had a natural law outlook. The ancient Greeks' conception was of a universe governed in a very particular way by an eternal, immutable law, and was characterised in their distinction between what is just by nature and just by convention. Stoicism provided the most complete classical formulation of natural law. Stoics argued that the universe is governed by reason or rational principle. They further argued that all humans have reason within them and can therefore know and obey its law. Because human beings have the faculty of choice, i.e. free will, they will not necessarily obey the law. If they act in accordance with reason, however, they will be following nature. That was the Stoics' point of view. In Roman legal thinking, natural law concepts emerged because of a very practical consideration. When the Roman Empire expanded, it embraced the legal systems of its captive nation. Because this empire was strung around the shores of the Mediterranean, there was ready access to cheap transport in the form of shipping, and trade consequently flourished. A problem arose, however, when a trading dispute encompassed two distinct legal systems. For example, if a Roman traded with an Athenian and a dispute occurred, by which legal system was that to be resolved? The Romans decided to develop a very practical solution. They authorised the praetors to formulate or fashion a new set of principles to deal with international disputes. This new law distilled the best principles from the various legal systems known to the praetors. It was for this reason called the law of nations. Roman legal philosophers then, drawing on the work of the Stoics, gave it a philosophical basis by postulating the existence of a natural law, a law of reason, which was eternal, immutable, and capable of universal application. It's typical of the practical Romans that a practical solution to a problem came first, followed by philosophical speculation about its nature afterwards. Nevertheless, legal philosophers are indebted to the Romans for providing a first-class example of natural law theory in operation in practice. After falling out of favour for some time, in the Middle Ages, natural law once again came to the fore. This time it was in the hands of the scholastic philosophers of the Catholic Church, whose most famous member at the time was St. Thomas Aquinas. Two major problems faced the Catholic Church. One was to justify its claim to preach and impose a universal moral code by which temporal rulers were to abide. Its other problem was to reconcile its own claims to authority based on revelation with the arguments of the Greek philosophers, whose works had been rediscovered, that man could ascertain truth by the use of his reason. It was the creativity of Aquinas that was able to provide an attempt on behalf of the Church at answers to both of these problems. Authority, Aquinas said, came from God, whose representative on earth, he said, was the Catholic Church. When God made the universe, he created the rules by which men should be governed. Temporal rulers were part of this natural order, but their authority derived from God, and they were subject to his laws, and God's representative on earth was the Catholic Church. Thus, both the basis and the limits of temporal authority was the law of God, whose guardian and teacher was the Catholic Church. Moreover, in ascertaining how men should live, reason and revelation were not in conflict, according to Aquinas, but were in harmony. To support this claim, he showed how reasoning would lead us to the same truth which God had apparently revealed. Now, whether or not we agree with that, we can see the creativity there of Aquinas in trying to fuse reason with divinity. And you can see the differing interpretations of natural law that have occurred through points in history. But there is a common thread in each of them about the inherent nature of natural law. So what is the nature of natural law? So far, we've considered the rise of natural law, and that account indicates its nature. We can expand that discussion with several propositions. First, then, the world has an obligatory moral order. This moral order exists because humans are not designed to behave in any way that they choose, but have an ordained nature to which they should conform. That's on the premise that there is a comprehensive, universal and eternal set of values by which humans should live. Consequently, according to Ronald Dworkin, a latter-day disciple of natural law theory, law is structured by a coherent set of principles about justice, fairness, and procedural due process. This enables the law in a particular society to speak with one voice in the face of conflict. This approach also finds judicial support. Sir Frank Kitto, for example, says that the common law and the law of equity, alike in their development, took constant account of the standards of fairness and reasonableness that prevail in ordinary life. Second of our propositions is that although this moral order is obligatory, it's not necessarily obeyed. All of us should comply with it, but its requirement continues however much we may depart from it in practice. Thirdly, this moral order is complete and consistent. It is also eternal and immutable, i.e. it always was and it always will be. Ronald Dworkin takes up this notion of consistency in proposing a norm for judicial adjudication called integrity. In the face of morally inconsistent principles, integrity, he argues, requires the law to speak with one voice. He adds that it enables and requires legislatures and courts to choose the principle which is superior, rather than to be vacillating between the possible principles. He argues that a court or legislature is able to make this choice if every principle is integrated and thus has a precise place in the moral hierarchy. In this way, he argues, integrity provides a right answer for every legal case. The fourth proposition that emerges is that being complete and inescapable, this moral order applies also to governments. Therefore, laws which are made by governments must direct the citizen to live according to this moral order. Thus, in making and interpreting law, civil authorities have to draw on and reflect this underlying moral order. Fifth, then, it follows that law does not create a code of behaviour at all. It simply articulates the existing rules of behaviour based on or derived from this underlying moral order. Law merely directs us to do what we should do anyway. Consequently, law does not consist of particular cases, but of general principles which underlie the cases and which the cases merely illustrate. To find law in a case, therefore, it's necessary to look for the reason and spirit of the cases, not merely the letter of particular precedents. The sixth and final proposition that emerges is that because law rests on an underlying moral order rather than upon an act of human will, in principle there is a simple way of determining when a law has authority. Validity of a law is measured against these pre-existing standards which are intrinsic in the world. In consequence, if a human law does not direct us to behave according to this underlying moral order, the law should be considered invalid and not a proper law. It lacks authority. This is the reason that natural law theory says that an unjust law is no law at all. The idea that the only law is a good law is expressed by a number of jurists. As Bustin puts it, natural law equates all law that is really law with the inescapable design of the universe. And that style of thinking, that school of thought, has found favour with some of the judiciary. For example, Lord Devlin. Devlin, a 20th century judge, was a deeply religious and fairly conservative man. He considered morality to be at the centre of legal systems, and in particular really Christian morality. He said, if men and women try to create a society in which there is no fundamental agreement about good and evil, they will fail. If, having based it on common agreement, the agreement goes, the society will disintegrate. For society is not something that is kept together physically. It is held by the invisible bonds of common thought. If the bonds were too far relaxed, the members would drift apart. A common morality, he said, is part of the bondage. The bondage is part of the price of society, and mankind, which needs society, must pay its price. So, if there is this underlying moral order in the universe, how do we go about ascertaining it? In other words, how do we discover natural law? How do we find it and the code of behaviour which it generates? Since natural law posits the existence of universal, binding and comprehensive standards of human behaviour, claims for moral authority will be supported by showing that humans can readily ascertain the existence and authority of these values. In short, the authority of natural law is no better than our means of knowing it. Hence, we need to turn our attention to the means by which humans can know the existence and nature of these standards. Several means are proposed on the slide. For reason, we include the process of logical deduction. Fans of Sherlock Holmes will know Sir Arthur Conan Doyle's fictional sleuth is famously quoted as saying, "When you have eliminated the impossible, whatever remains, however improbable, must be the truth." There is a sensibility to this type of reasoning as it follows pure logic. It doesn't, however, create moral authority. as it is merely logical on existing factual parameters. Another problem is that it can't discover new truths. It relies on prior truths. Another type of reason, called induction, involves reason by analogy, so using specific examples or cases to come up with general rules. This is arguably part of the logic of precedent, judges applying similar principles to new situations. However, it isn't robust enough in itself to be the source of the law, nor really does it explain who invented the first specific moral rules which were to be extended into generality by analogy. Some use revelation as a source of moral authority. In the Christian tradition, revelation goes back to the account of the creation of the world in the book of Genesis. God made the world in a physically ordered way in 6 days. On the seventh day, God rested. This can be taken as an allegorical account of the creation of moral order and the ever-presence of God among his people. Humans, therefore, according to the Christian tradition, are created by God with a certain nature, which God has commanded them to follow. God's commands are made known to humans by revelation in the Bible, both in the Old Testament, for example the Ten Commandments, which tell us what not to do, and in the New Testament, for example the Sermon on the Mount, which tells us what we should do. This version of natural law is neatly summed up in an evangelical religious slogan: "For best results, follow the Maker's instructions." This was taken up and fused with reason by the philosopher and theologian Thomas Aquinas, as mentioned a few slides back, in the 1200s, arguing loosely that reason would guide man to God's truth. But revelation isn't accepted by all, particularly non-Christians. So another alleged way to know the moral order that natural law commands is possession of esoteric or specialist knowledge. Sir Edmund Coke expounded the view that the moral authority of common law was known only to lawyers. This knowledge, he proclaimed, was imparted by legal training. It was gotten by long study, observation and experience. Without being totally specific, statements such as these suggest that judges can find the right or best answer due to some esoteric specialist knowledge acquired by legal training. Needless to say that there is a problem with this view, that reason is imparted by special legal training. It's a hard claim to prove that lawyers somehow possess a monopoly in moral wisdom, and that there is somehow some special professional moral reasoning that is exclusive to lawyers and lawyers only. And so we come on to the last of our possible sources, which is innate knowledge. Several strands of thought put forward the idea that humans have some sort of innate view of underlying moral standards. There are two grounds used to support this view. One is an argument on common sense, and the other on instinct, literally. If we all have innate knowledge of fundamental principles, they will be universally known and hence widely recognised. The argument has some force, but showing that values are shared, even widely, doesn't prove that they are innately acquired. This leads us on to consider some of the problems then with natural law. In predicating standards of justice and rationality, natural law has an appeal for all of us. There is a widespread desire that justice and rationality should be the basis of our legal system. Unfortunately, this is a major deficiency of natural law. The unanimity therein ends. There is not comprehensive agreement about what justice and rationality entail. While the voices of reason and revelation and claims to innate or esoteric knowledge may be convincing to those who hear them, they're not to others. Put simply, revelation is a matter of faith, and reason is a matter of dispute. In consequence, neither the secular nor the sacred claims of natural law are universally accepted. In practice, this difficulty can be overcome only when a society is either highly unified or highly subservient. These conditions obviously existed in medieval Europe, which accepted the moral authority of the Catholic Church. When these conditions are not present, however, such as is the case in a pluralist society like ours, it's hard for natural law to gain widespread acceptance. To put this from a practical point of view, philosophers and others have argued for centuries about moral and ethical questions, and eminent lawyers frequently disagree. This is illustrated by the fact that decisions of superior courts, such as the Supreme Court, as is now formerly the House of Lords, or the Court of Appeal, frequently involve dissenting judgments. Thus, the answer seems inaccessible, and so for practical purposes, it might just as well not exist. On this basis, the argument that natural law is the source of law isn't rejected as unsound, but as deficient. It's not able to deliver a rule to resolve the conflict between principles. So, having highlighted some of the deficiencies of natural law, what other schools of thought are there as to the nature of law? In the third and final part of the podcast, we'll consider the merits of positivism as supporting a school of thought for the nature and the basis of our legal system. In the first two portions of this podcast, we considered generally the question, what is law? And particularly in the second portion, we looked at natural law as a school of thought, trying to explain the nature of law. Towards the end of the second portion, we considered some of the deficiencies of natural law, and so now we look to an alternative explanation in the form of legal positivism. In the winter of 1763/64, Jeremy Bentham, an eventual philosopher but then 15 years of age, attended a course of lectures in law at Oxford given by Sir William Blackstone. Blackstone was an exponent of natural law. It's said, though, that even at the age of 15, Bentham disagreed intensely with what he heard. This reaction to natural law in part started a school of jurisprudence known as positivism. The name positivism derives from the fact that one of the principal tenets of positivism is that law is simply what the sovereign or lawmaker posits or lays down. This is in sharp contrast to natural law, which insisted that law must conform to certain standards of justice and morality, or it would be considered invalid. Positivism made no insistence that law be defined and identified by reference to some metaphysical standards of justice. Instead, law was simply what the powers that be, the sovereign, laid down. So there was no consideration of any moral code to validate the law in positivism. It was entirely man-made and made for whatever reason those in charge wished. Issues of legal validity must be strictly separated from questions of morality. What the law ought to be has nothing to do with what the law actually is. In terms of the origins of positivism as a school of thought, most theories don't arise spontaneously, but are a reaction to the actual or perceived deficiencies of other theories. Positivism is no exception to that, and in fact was a reaction to a defect in natural law theory. Natural law concentrated on authority and legitimacy. Its main concern was to formulate a test for a valid law. According to natural law theory, a law was valid if it complied with the order, rationality, and morality that, as a matter of principle, underlay human affairs. In doing this, natural law was not explaining political power, and this is the defect that positivism filled. To understand positivism, look at a politically advanced state such as Britain in the second half of the 19th century, in the Victorian era. A very noticeable feature would be that power was first and foremost a fact, not a derivative of some moral claim to authority. In such an environment, power operates. If you do not obey the law, a policeman arrests you and a court sends you to jail. Laws are made and obeyed without any reference to political or philosophical debate about authority. Power is a fact or a state of affairs. Might may not be right, but in a real sense, might is enough. Thus, in explaining law, positivists started with facts about power. In contrast, natural law theory had started with a view of human nature. From this, positivism deduced a criterion for determining whether a law was valid and legitimate. If a law was valid, then the law itself had authority and thus bestowed authority on the government which made it. Positivism's formulation takes a very different view of human nature to natural law. It takes a very pessimistic view, solitary, individualistic, rational, self-interested, disorderly, and violent. As a consequence, it sees the purpose of law as maintaining conditions of cooperative order amongst what would otherwise be inherently nasty and brutish human beings, and it sees the nature of law as commands of the sovereign charged with maintaining order backed with some force. In order to assess that in some more detail then, let's look at some of the early formulations of positivism. I've already alluded to Jeremy Bentham, and similar views to Bentham's were put by John Austin, and in our broad coverage it's convenient to treat their analysis together. Now, Austin sought to develop a science of law, a jurisprudence, and to systematise and rationalise our thinking about law and demonstrate the logical structure of legal systems. Austin's theory offered a theory for his times which would explicitly recognise the modern dominance of legislation, the active lawmaking of the modern state, and the idea of law in flux as a purposive human creation. According to this, law has no necessary connection with any given set of moral norms. Law is separate and different from morality in this sense. It became necessary to delineate the subject matter of legal science. Austin set out to distinguish law, legal argument, etc. from other similar phenomena with which it could be confused, for example, morality, moral argument, etc. He observed the existence of law is one thing, its merit or demerit another. In Austin's definition of law then, there is a sovereign, and every law or rule is a command. Law is fundamentally an exercise of power and is fundamentally linked to sanctions. A sanction is an evil which will probably be incurred in case a command be disobeyed. Sanctions are essential to law. No sanction, no law. A legal obligation or duty is being liable to an evil from you if I comply not with a wish which you signify, as Austin put it. There is no more to the notion of legal obligation or duty other than the fact of being subject to a sovereign command backed by sanction. The purpose of law then, according to Austin, is fundamentally effective government, not the protection of natural rights or the realisation of some other social good. All of these requirements have been the subject of scrutiny and debate. However, because A, the identity of lawmaking authority is generally not in doubt, and B, command almost implies both obedience and sanctions, positivism is popularly represented, as it is in this podcast, as the view that law is what lawmaking bodies say is the law and nothing more. But there are problems with such a simplistic assessment. In 1745, there had been a major uprising by those who supported the claims of the Stuarts to the throne of England. It may be sufficient for a time to have power, but the throne and the state were generally more secure if they also had authority. Therefore, after positivism made the point, valid as far as it goes, that power has to be reckoned with, it had to do something else. It had to see how law could also have a moral claim to authority. Hans Kelsen attempted to deal with this question for positivism. To get to grips with his reasoning, we can start with the notions of command and sanction. Thou shalt not steal, for example, is the command, and the sanction is arrest by the police, trial, conviction, and punishment. But what if the policeman does not arrest? Then there is a law telling policemen what their duty is, and there is a sanction for breach of that law. But what if the sanction is not applied? Then a further sanction operates. Obviously the process could go on in infinite regression, because the enforcement of all laws depends on a sanction imposed by another law. So positivists encounter the dilemma as articulated on the slide in the Latin aphorism, quis custodiet custodes ipsos, variously translated as who watches the watchers and who guards the guards. Kelsen's way to try and avoid this dilemma was to redefine the concept of rule. No longer is a rule a simple command, compliance with which is sanctioned by another rule. Instead, rule was defined to include its own sanction. Thus, where earlier positivists would say that there are two rules, A and B, with A saying thou shalt not steal and B telling policemen to arrest thieves, Kelsen says the rule is if A is, B ought to be. In concrete terms, Kelsen argues law has the form if you steal, then a policeman is obliged to arrest you. In this way, rules are defined as inherently ought propositions, which Kelsen describes as norms. However, norms don't exist as a simple list of obligations. Instead, norms are derived from other norms. Thus, a policeman's power and duty to arrest may be derived from statutes from the Constitution, and the Constitution from the Crown. Norms therefore exist in a hierarchy. There is a chain of command. However, the hierarchy has to have a head, because ultimately there must be a fundamental norm. This Kelsen described as the Grundnorm. For Kelsen, the Grundnorm is assumed to exist in any established legal system. But this, of course, is Kelsen's problem. All he did with his hierarchy of norms was to duplicate the same problem faced by earlier positivists, quis custodiet custodes ipsos. An attempt to lead positivists out of this difficulty has been made by one of the latter-day disciples of this school of thought, the jurist H.L.A. Hart. In his book, The Concept of Law, Hart's explanation starts by viewing a primitive society which has simple rules of obligation such as no stealing and look after the sick, but no institutions such as courts, police and parliament to implement the laws. In this society, the authority of rules will rest on what he terms a habit of obedience. However, three problems can and eventually must arise. First, there will be doubts about what the rules are. Second, the rules will be static because no one would have the ability to change them. Third, there will be no means of resolving disputes and enforcing the solutions. Consequently, it's necessary for this model society to develop rules to perform these additional functions. To distinguish the two sets of rules, Hart called them primary and secondary. Primary rules are the basic rules of obligation. Common lawyers call this private law. Secondary rules are ancillary to the primary rules and perform the functions just described. Common lawyers call this public law. Secondary rules Hart classified as rules of recognition, rules of change, and rules of adjudication. From this framework, Hart was able to launch his analysis of authority. Authority, he argued, does not rest on the habit of individuals in obeying, but in acceptance of secondary rules as common standards of official behaviour by officials of the system, legislators, judges, police, and civil servants. In this way, Hart raises the definition of authority from habit of obedience, which may be diversely motivated and not very realised, to instead consent, i.e. the necessary and identifiable acceptance by officials of certain constitutional rules. In this argument, Hart is drawing on the consent theory of political authority to create a consent theory of jurisprudence. It has its critics, but has an obvious strength and an intuitive appeal in that consent does confer legitimacy. Interestingly, it's also an argument for the right, or the potential right in the case of the UK, of a citizen to bear arms, so that they are able, if needs be, to launch a rebellion against an unjust regime. This doesn't necessarily mean though that Professor Hart had solved all of positivism's problems. As a widely accepted and influential philosophy, positivism has been subject to much scrutiny and criticism. Firstly, positivism does not tell us much about the law. What it says is as arid as it is obvious. Most of us know that in some sense law consists of statutes, cases and delegated legislation, but to delineate law from non-law in this way tells us nothing that we didn't know already and nothing else that is useful about law. To define law as the utterances of Parliament, Parliament's delegates and the courts is akin to defining poetry as literature in metric form. Such a definition probably distinguishes poetry from the rest of the universe, but in no sense conveys the imagination and creativity behind poetry. Similarly, positivism tells us nothing about why or for whom law is made or how it operates. To say that law consists of the statutes made by Parliament tells us so little. It also refuses to face the real and pertinent questions about the nature of law, its origin and functions. To illustrate the point more specifically, Kelsen explains sovereignty as his grundnorm, which is simply assumed. Thus he does not answer the question of authority, but evades it. As a second criticism, not surprisingly, the claims by positivists that a legal system is amoral has been one of the major targets of criticism. Claims that law is merely the will of Parliament run counter to our instinctive beliefs that law can and should be a force for good. Indeed, justification for its impositions and demands is that it is serving the community good. One of the claims frequently made by lawyers and politicians is that we should live by the rule of law. That is, that a just and sensible legal system is part of a stable and civilised society, and the divorce of positivism from morality potentially undermines that commonly held belief that law is a force for good. A third criticism comes in the fact that it hides behind the rule of law to legitimise itself. Positivism as a current legal philosophy, accepted by many lawyers, judges and lawmakers, stops its inquiry after it has identified law. Law is what Parliament and courts say it is. More insidiously, the authority of law is asserted by circular implication. Because law is what Parliament says it is, then Parliament must have authority to make it, and therefore it must be obeyed. The law is the law, and no more needs to be said. Thus, in the merry-go-round of argument put up by contemporary positivists, law achieves authority and an immutability which would be the envy of most natural lawyers. Positivism's ally in this dubious quest for legitimacy is the rule of law, which is similarly stolen. Behind the rule of law is the notion that it is better to be ruled by laws than it is by the discretion of a ruler or a tyrant. As far as it goes, this sentiment is unimpeachable. However, the fact remains that some laws are unjust, and it's little consolation for people who are ruled unjustly to be told that they are ruled by law. Therefore, the rule of law, if it is to mean anything, must have something to say about the quality and justice of laws. In recent times, therefore, jurists have argued that the rule of law urges a legal system to observe minimum standards of justice. Unfortunately, modern reference to the rule of law in political and constitutional rhetoric does not recognise this point. Politicians making law and order an election issue use the rule of law to justify blind obedience to the law as it is, and omit that part which would cause law itself to be scrutinised and changed. Thus, the rule of law becomes an ally of positivism, investing the law with an undeserved authority and an unreasoned immutability. As a result, the law becomes something separate from society, something mystical, beyond reason and beyond reproach. What we've been considering during the course of this podcast is commonly referred to as the heart-Devlin debate, for obvious reasons, and deals with the nature of law. But as we have seen with the two major theories on the nature of law, each has its own faults and pitfalls. The debate is clearly more complex, and there are of course other justifications, explanations and views as to why we have law and why it is the way it is. Law is more than just a system of rules and has to be seen and studied in context to be truly understood. There's an array of wildly diverse opinion, and we'll explore these as we progress through the course. Some of these other opinions would describe themselves as theories on the nature of law, and others either have a bearing on the law or are perspectives on it, based in different ideologies. The important thing to remember is that law does not stand in isolation as a thing, as many imagine, but is instead intertwined with politics, economics, theology, sociology, and even psychology.